Okay, in this video, I want to take a look at a new piece of legislation that's supposed to come into effect in January of 2018, and that is the Mediation Act of 2017. It might provide a way for people to resolve their disputes without going to court, and the purpose of the Act is to encourage mediation between the parties. So, as I say, it's expected to come into Irish law in January of 2018, and the purpose is to allow parties to a dispute to avoid the cost of litigation and to reduce the number of disputes coming before the courts, and therefore perhaps make cases that are in the courts and are in the lists progress more speedily. What is mediation? It's essentially a collaborative process. It aims to encourage the parties to a dispute to arrive at their own solution with the professional assistance of the mediator. The mediator is to facilitate the parties and provide his or her professional expertise and experience, but the determination of the dispute, the final outcome, is up to the parties themselves. The mediator can make proposals to resolve the dispute when the parties request this. In relation to solicitors then and commencing legal proceedings, solicitors have obligations set out in the Mediation Act 2017. Before commencing legal proceedings on behalf of a client, a solicitor will have to swear a statutory declaration that he has advised the client of the availability of mediation as a way to settle the dispute. He must also let the client know about the benefits of using mediation as opposed to commencing legal proceedings, and he must give the client names and addresses of mediators who may be able to assist in resolving the dispute. The Mediation Act will not apply to certain proceedings, for example, High Court judicial review proceedings and an arbitration under the Arbitration Act of 2010. Courts then have a role to play in the Mediation Act. The court will be allowed to take into account, when awarding costs, any party's unreasonable refusal or failure to avail of mediation. Section 19 of the Act allows a court to adjourn court proceedings to facilitate mediation. Section 16 provides for a court inviting the parties to engage in mediation. And Section 17 provides for the mediator to provide a report to the court to explain why the parties have not so engaged, or to explain why the mediation has failed, and that they wish to commence or re-enter legal proceedings. The Mediation Act of 2017 is to be welcomed. It should allow more parties in dispute to resolve their issues without the cost of going to full-blown legal proceedings, including a court hearing. It remains to be seen how effective it will be, but certainly it's another option that parties in dispute should be able to avail of. Also, if you are an employer, it cannot do you any harm to insert a clause in your employment contracts from now on, providing for the use of mediation before instituting legal proceedings. This essentially means that if somebody is going to sue you as an employer for breach of contract, you will be able to go into court and look to have the proceedings adjourned pending the use of or the availing of mediation. Now, obviously, you can't do that in perpetuity, but it may be something that will allow both sides to kind of cool down and see exactly where they're going in terms of the litigation. There are my contact details there. If you find the video useful, you might give it the thumbs up down below, and you might be interested in subscribing to my YouTube channel. Thank you.